I'm Annie Fitzsimmons. I'm your Washington Realtors Legal Hotline lawyer, and this is a video in our continuing series entitled Overconfident Sellers plus Overeager Buyers equals Broker Liability. And today I want to talk to you about sloppy practices. Now, this is not something, I told you earlier in this series that in every video I'm going to help you understand how to explain the risk to your clients, how to avoid the risks, and how to document your file. And I guess I'm stepping aside from that with respect to this particular video because this is just a warning to you brokers. This doesn't have anything to do with your clients. In this busy, crazy, chaotic marketplace, brokers are forgetting some of the most basic practices that are necessary to keep a transaction together, to avoid liability, to even avoid breach of contract for their buyers and their sellers. And we're going to talk about some of those. Brokers, when you email an offer back and forth, offer, counteroffer, back and forth, every single time you email, you email every single document that makes up that offer. You don't just send back the counteroffer addendum. You don't just send back the one page that had revisions on it that you need initials to. You send back the Form 21 and the Form 22B and the 22A and the 22D and the 22T, everything that's part of that agreement. You put it in a PDF and you send it every single time. Why? Because when it's all signed and we have mutual acceptance, we don't want there to be any question in anybody's mind as to which documents are part of that agreement. You can have an indexing. You can keep the index on the blank spaces on the face of Form 21. You can have a separate cover letter. You can have a separate index sheet. You can have all of that stuff, and all of that stuff is important. It's important to have an index somewhere. But it doesn't replace the fact that you create a PDF of the entire document, all pages of the document, every single time you send it back and forth, offer and counteroffer. Okay. Deadlines. Missing deadlines is becoming a problem. In Form 22B, for example, you have a home sale contingent buyers. Buyers are selling their houses so fast now, the problem used to be that seller would sell to a home sale contingent buyer and the risk was that the buyer was never going to be able to sell their house. Now buyers are selling their houses so fast that buyer brokers are forgetting that they've got to put the seller on notice of the fact that the buyer sold their house. They've only got 2 days once the buyer sells their house to put seller on notice of the fact that the buyer sold their house. If they don't, buyer, you're in breach of contract. Another example. Buyers are expecting homeowner association documents under the Form 22D provision. The Form 22D provision says that the buyer's right to terminate based on that homeowner association document review provision runs from the date that those documents are delivered or the date that those documents were due. So a buyer never receives the homeowner association documents under the document review provision of Form 22D and doesn't terminate the agreement on that basis, buyer loses the ability to terminate the agreement on that basis. Another sloppy practice. Buyer brokers failing to investigate with their buyer where the buyer's purchase funds are coming from. We know that the buyer is going to get a loan and use a 22A to document the fact that they're getting a loan, but what about the down payment? What about their closing costs? Remember that paragraph A of Form 21 says that buyer is not relying on a contingent source of funds unless otherwise disclosed in the agreement. Buyer broker, you failed to ask your buyer, where are you getting your down payment? Where are you getting your closing costs? If the answer to that question would have been, I'm getting it from a contingent source of funds, and understand that a contingent source of funds is everything, except for a bank account in buyer's name in a U.S. bank. So if the funds are a gift from grandma, or they're in an investment account, or they're in a retirement account, or they're going to come from the sale of my really cool car, or wherever those funds are tied up right now, if they're not in the buyer's bank account held in buyer's name, then they are contingent funds. And the fact that they're contingent funds has to be disclosed in the purchase and sale agreement. Buyer brokers are not asking that question of their buyers so that buyer brokers can then pull out Form 22EF and make it part of the transaction. It's not a separate contingency. It doesn't give a buyer a way to get out of the transaction, but it's a necessary disclosure of the fact that the buyer is in fact relying on contingent funds for the closing of the transaction. Another problem we're seeing is brokers coming right up onto the closing date and then asking for an extension. In this crazy seller's marketplace, seller may not grant that extension. Seller may be thrilled for buyer to be unable to close the transaction timely, meaning that seller can move on to the backup buyer who's going to pay $50,000 more. You, buyer's broker and buyer, have no idea that there even is a backup buyer. Buyer brokers, you cannot count on the fact that the seller will give what you believe to be a reasonable extension of the closing date. It may be that no extension of the closing date is reasonable to the seller who wants to get rid of your buyer. So buyer brokers, if it looks like you're going to need an extension of the closing date, take care of this well before the closing date is upon you. Because it may be that the seller won't give you an extension of the closing date, and if you have enough advance time, then perhaps you can put some more pressure on the buyer's lender, help the buyer's lender to understand that the buyer cannot get an extension. It's important that we get the closing documents. You might even have to go pick up documents and drive them across town or something like that. But don't count on the fact that a seller is necessarily going to give you an extension. Sloppy. And the last sloppy practice I want to bring to your attention, and designated brokers, I guess I'm speaking to you mostly right now. Review documents before they leave your office. I am seeing more and more examples of crazy provisions that brokers are drafting. And I don't want to blame new brokers, because I'm sure it's not all the result of new brokers in the business, but we are seeing new brokers entering the industry right now at enormous rates. Designated brokers, remember that you are responsible. You're both responsible to the Department of Licensing and liable on a civil basis for every real estate brokerage service that occurs by one of your real estate brokers. So when one of your real estate brokers drafts a provision and it doesn't make sense, it's up to you to intercept it before the client signs it, before it gets out into the marketplace, before it becomes a binding transaction. Brokers, it's up to you to get the assistance you need from your managing broker or your designated broker. Can't encourage all of you enough to make sure that the drafting that brokers are doing, I'm not talking about filling in the blanks, putting a number 10 in the inspection contingency. I trust you to be able to do that. But when you put fingers to keyboard and you write provisions wholesale, get those provisions reviewed before your client signs them. Let somebody else in the office take a look at them to tell you whether or not what you just drafted says what you think it says. Show it to them and say, what does this language say? And if they don't tell you that it says what you thought it said, then you know you've got a problem and you need to start over with your drafting. And get help with your drafting. It's not easy to write contract language. These are some of the sloppy practices that we're seeing as a result of really what is a chaotic marketplace out there. If you need help with any of these issues, I cannot help you draft specific contract language. I don't represent you. I don't represent your clients. I would advise you in those cases to seek legal counsel if your managing broker can't help you. But with everything else that we've talked about, if you want to talk about any of those issues or you need assistance in working through them, please send an email to me, legalhotline@warealtor.org. Thank you for being a Washington Realtors member.